One of the key deficiencies that I've noted is in the area of taking care of cloud-specific legal risks. So these would include, first, beefing up the KPIs in a few key areas. The first would be areas such as privacy and confidentiality, simply because in the cloud environment, you are entrusting a fair bit of your data onto a virtual vault in some cases. And you are going to be expecting a lot of data flow from your organization into the cloud, i.e. the internet, and from the cloud into the secure websites. Therefore, the end-to-end security requirements must be tightened up, and that tends to be left out in many of the current generic service level agreements, which are based on standard IT services agreements. They just don't work. The other area that needs to be beefed up is, besides the privacy and data protection area, is the area that, with regard to KPIs on the internet connectivity. That's one area where I don't see enough focus. The general feeling is that the internet is something where there's no quality of service, and therefore there cannot be any KPIs. But the fact is, when an organization says it's going to provide a cloud service, inevitably the customer will expect that some degree of assurance will be there with regard to availability of the service. If someone can put in a contract a statement along the lines of, I'm providing a cloud service, however, if the internet is not available at my end, it's not my fault, I don't think that's acceptable anymore. It used to be in the early days when the internet was clearly a variable and was not so critical to the availability of a service, because the service generally ran on the customer side. But now there is nothing running on customer side. The only way you can access service is through the internet. While it is possible to accept risk where it is a failure on the customer's end in terms of his own internet access, that's fine. That's beyond the service provider's control. But where the service provider themselves have an issue with connectivity, I don't think that's acceptable in terms of excluding liability. So that has to go out, and I still see that clause very much in SLAs today. It's not acceptable. So you would expect a certain degree of redundancy for such service providers. I don't see that happening enough as far as the contracts are concerned. Technically, yes. You'll find obviously the best cloud computing environments will have 2 or 3 potentially telco service providers. So if one fails, they can jump onto the other. But they're not passing that down in terms of the contractual risk. They still expect the customer to take that risk. No go. They are seeing it more and more these days. However, in most contract negotiations, people tend to focus on the front end. That means the main terms and conditions, while the SLAs are treated as technical terms. And sometimes people don't really, therefore, view these areas carefully. And as I said before, from many IT managers' perspective, they still unfortunately view cloud services as another IT service. It is not. It is fundamentally different because of the nature and the manner in which the service are provided to you is totally through the back-end connectivity. And without that assurance that some connectivity guarantees are given by the service provider, you could end up with nothing. You could come into work tomorrow, expect to log in and use your Microsoft Word virtually on a Azure platform, for example, and you can't connect it, not because of any failure on the part of your ISP, but your service provider ISP has failed. That, to me, should be seen as a failure to provide services. It cannot be subject to exclusion of liability. And people don't really see it because it's still early days. It is a new area that is being set up, at least speaking from a legal perspective. Certainly, cloud computing, if you look at Salesforce as an example, has been around for a fair bit. It's only now that the customers are increasing in terms of sophistication, in terms of addressing the legal risk issues. And they're asking the hard questions. So it's good to see. All I'm saying is that they could ask a few. I've touched on the first two, which would be, as I mentioned, looking at the network connectivity aspects and the other points that I've mentioned. One additional point I would add on to it is the issue of intellectual property rights. This is a very touchy area because, again, in a standard cloud computing environment, let's say we're using a service aggregation by, for example, Jamcracker, or some others along those same lines. So they will pump through their infrastructure multiple applications essentially to you. The question always, as far as the end user is concerned, is what right do I have then over such software? It's a lot simpler in the early days when you have a CD, you have some, or obviously some form of right to use that CD and right to install that application onto your server or onto your end user site. You have some degree of physical control. Here you have no access at all to the applications. They're all pumped through to you through the internet. you obviously have a right to use, and that has to be reflected properly. The scope of that right is something that has to be properly defined. In the early days, when you have a standard license term, that works fairly well. In these days, from the examples that I've seen, there are two broad models. The first is where you have a pass-through model, meaning the aggregator simply passes all the same rights that were granted by the original software owner through to you. So you have a document which states, your right to use. But these days, I often see as well certain content aggregators or service aggregators providing a bespoke license document, which seems to say that you have the right to use applications that we provide to you from time to time, and you have no ownership rights at all, and nothing in this agreement seeks to grant a license to you. To me, that is an unacceptable position, because if you don't have a license, what then do you have? A right to use is often what a license is defined to be. So you're telling me on one hand I don't have a license in law, I have a right to use applications provided to me. It's an inconsistent message that I'm getting. And I'm sure if I'm confused, the end users will be even more confused as to what right specifically they're getting. So I think that it's useful for end users to scrutinize these licenses carefully, the rights to use, as the vendors like to put it, and understand clearly whether or not these licenses are crafted in a consistent manner. To me, if I see those two statements in one license agreement, I'm not getting a clear message. I would take one of them out. Generally, I would take out any statement to the effect that nothing in this agreement grants me a license. Because to me, and to most lawyers, I hesitate to say all lawyers, a right to use does constitute a form of a license with regard to the usage of that software.